May 6th, the House Commerce Committee on the Committee on Commerce and Economic Development, 8:30-ish, and we start with Attorney John Gray do a walkthrough of H-121.
John Gray, Office of Legislative Counsel. I will screen share. Yeah, that's pretty good. Okay, so you guys have seen this many times, but it's been a little while. We're jumping back into data privacy. The highlighting that you're going to see here is the changes relative to the version as passed out by you guys, passed out by the House, not against what the Senate has done. And obviously that's still ongoing. My understanding is that this language is being considered, and this is what you see in the strange header at the top for inclusion in S289. So with that, I will jump in and I will call out where there are changes. Some of it you won't see, and I will try to call that out. Others should be in highlighting. When I say that you won't see it, it's a deletion. So the first piece is just the first definition previously was abortion. This is a cleanup change to remove that because there were no other references that pulled in that term, so it wasn't necessary to call it out. It's not a substantive change. This doesn't affect anything about reproductive health or the like. This is just cleanliness, basically tidiness for the document. There is a change to biometric data. So this is a fairly substantive one. This is essentially accepting what Senate Economic Development proposed to the definition of biometric data. You may recall that previously this list of, and just to reorient, biometric data is a kind of sensitive data. So we're talking about opt-in consent for this kind of processing. Previously, biometric data included as subdivisions 7 or Romanet 7 and 8, photographs, depictions, images, recordings, and then data derived from those pieces. What you see now is those have been pulled out and replaced with biometric data does not include those digital or physical photographs, audio or video recordings, or any data generated from those photographs or recordings, unless, and this is key, unless such data is generated to identify a specific individual. So what this is meant to say is just regular images and the like are not meant to be picked up by the definition of biometric data. That's not going to be sensitive data that requires opt-in. However, if people are generating the face templates that you see above or other things from those photographs or recordings, that would be a kind of biometric data. So this is a nice separation aligned with other states, allows you to get at the kind of harm that you were trying to get at, I think, with those previous categories, but avoids essentially cutting off a lot of transfers of images, depictions, recordings. So I think that this is a safer position, a more defensible position to be in, and still lets you get at the same kinds of harms that you were trying to get at. We'll jump down to heightened risk of harm to minors. There's one change here which you won't see. Yes, heightened risk of harm to a minor. In speaking with others, this subdivision B about processing personal data of a minor in a manner that presents a reasonably foreseeable risk of financial, physical, or reputational injury. This has previously contemplated emotional and mental injury to the minor out of a concern that these might be too expansive to put you kind of in a more defensible place. Those have been removed and to align with the approach in other states. And I think that this is also aligning with Kids Code, although admittedly I don't know as much about Kids Code to say. But this is kind of a safety type change. It still preserves the other kinds of injury here, including importantly reputational injury, which is sort of in the same vein, but more precise than just what is mental injury to a minor. We're not sure. I can jump down to precise geolocation data. This aligns essentially with the approach taken in other states, except that we use a radius of 1,850 feet, which is broader, so it's more protective than what other states use. It's common to see 1750. I think that California uses 1850. Basically, the previous definition you had captured this same content, except that it had a line that, in effect, and it's interesting that no one really went into this, there was a line in the previous draft that essentially made any data generated from a phone, precise geolocation data, whether or not it was used or could be used to identify a specific location of a consumer. So that has been pulled out. I don't think that was probably anyone's actual intent. So this aligns with other states. This is still getting at the same kind of data that you want to get at. Publicly available information. This is a change to add in a new piece to make clear that biometric data that is collected by a business about a consumer without that consumer's knowledge would not be publicly available information. So this is, someone's just taking a picture, you're sitting in a cafeteria, whatever it is, you can be seen there, but if people start generating biometric data from that, that would not be considered publicly available information just because you happen to be sitting out in public. They had to take that step to create the biometric data. And this is a way of ensuring that, because as you'll recall, publicly available information is not part of the category of personal data, which means it is not regulated under the Act. So if biometric data otherwise met the common sense understanding of what publicly available information was, you can imagine that all kinds of face scraping and just people sitting out on a sidewalk and capturing folks would be not picked up at all by the Act. So this is a way of making sure that you do get at those kinds of biometric data. And this is consistent with, I know that Maryland just did this. It may be that other states are taking this approach, but this is a newer piece, I believe, but one that is consistent with the intent that you guys have had, and I think is more protective of consumers.
Can I ask as we're going along, or do we need to wait until we get through the document?
I think it's fine to address it. Go ahead, Edie.
Okay, thanks. So on the publicly available information does not include biometric data collected. Do we need the word biometric there? Does not include data collected by a business about a consumer without the consumer's knowledge, or is that?
We do need biometrics because if you have just generally data collected without the consumer's knowledge, that really is kind of common sense understanding of what publicly available is. So we're not trying to restrict. People can take pictures or capture folks out in public. You don't have an expectation of privacy in public in that sense. So we're not trying to disrupt it so that anywhere you go, people cannot do things, about you. They can't capture your speech or the like. We just don't want them to use that information in particular ways. I'm saying we, it's you guys. You guys don't want them to use information in particular ways that are threatening to consumers. But we don't want to run into free speech concerns with just folks out and about, regularly understood publicly available information. They can no longer collect it. They can no longer transfer it. We're not trying to cause that huge alteration in how public interaction works. That's not what this is meant to do. This is just meant to get at a specific kind of heightened harm. And as we talked about with the category of biometric data, we're also talking about something that requires a little bit of a step, right? Those facial templates and fingerprinting and the like, that's not something that you just immediately have by virtue of being out in public. That's a step taken to identify someone on the basis of information. Does that make sense?
Yeah, thank you. I appreciate that.
Jim, you had a question?
Yeah, as long as we're jumping in, I was looking at the biometric data
Mhm.
and the things that you're collecting, and it struck me that maybe included in that, we should include tattoos and other body decorations.
So that's interesting. It's definitely something that could be used to identify a person.
Cops do it all the time.
Right. Data generated from the technological processing of an individual's unique biological, physical, and physiological characteristics that's linked or reasonably linkable. So I think it would depend. I get as this is set up, the tattoos would not be picked up as just a physical photograph, but I'm trying to think of what technological processing of that would be that allows for reasonable linking that's beyond just a photograph, because we are trying to accept the Senate compromise here of excluding those photographs. And I think it's clear from a photograph that you can just look and make an identification of tattoos. if it was something that went beyond that. So I guess maybe the third piece here is, to your point, any data generated from that photograph to identify a specific individual. So if that was the purpose of doing it, then I think there is an argument that it's not excluded under this B3. But we're not trying to prohibit the photograph itself. It's just meant to be if people are essentially setting up a database of identification on those purposes. I think that's what we're excluding, but we're not otherwise excluding the photograph. I don't know if that's a satisfactory answer.
Wouldn't tattoo be the same thing as like normally identifiable things like hair color, eye color?
Right, it is a kind of physical characteristic that is reasonably linkable to an individual. So it's captured in the concept. I'm just trying to, like this right here, it is a unique characteristic that can be linked to them very obviously. I'm just trying to draw out how that would be different than, say, a fingerprint. A fingerprint, you take an active step beyond taking a picture of someone, right? And we're saying the picture is excluded. The fingerprint, it's obvious that we take a step to do that. I'm trying to think about what the extra step beyond photograph is for tattoos, because it's so obvious that from a picture, we can just identify a particular person. So I think it goes to something like, are we generating, similar to face mapping geometry or templates, are we generating data for the specific purposes of identification? I think this is what this concept does pick up if you're generating for the specific purposes of identification, but doesn't otherwise limit just the photograph person who happens to have tattoos.
That's a non-exhaustive list, right? This is just.
It is not exhaustive, but I think it is important to say B does definitively exclude from the concept digital or physical
Right.
photographs and audio or video recording. So we're not saying it might fit under the non-exhaustive list. It is excluded under B definitively, and we're just talking about picking up that extra step taken to identify a specific individual.
I don't know where this was now. I lost my place. But we took out mental and psychological injuries.
You're talking about a heightened risk of harm to a minor.
Sorry.
Oh, you're good. Yes, from B.
And I'd just like to flag for future reference that we're doing a whole lot in healthcare to have parity between mental health and physical health.
Mhm.
And from my perspective, that takes away some of the mental injury and the significance of that. So,
No, I totally take the point. And
if we're working so hard in one area, it's unfortunate that we can't also have parity in this. And I'd like that to be flagged and on the record.
And to your point, what we're talking about when we talk about heightened risk of harm to a minor is that controllers offering online product services to known minors or that they should know essentially are minors. So when they're reaching out to those minors, we're talking about them needing to take steps to taking reasonable care to avoid this kind of harm. And it's very clear that emotional kinds of harm are major pieces of what goes on with kids, if not the major thing that happens for kids. So I think that's completely fair. I hope that the reputational injury point can take up some of those same pieces, but within a more cabined area. But that's completely fair. Mental, that's one of the most dramatic impacts that you can have from these pieces. I'm guessing kids probably are more concerned about that than the financial impacts of them.
So I don't know what else to do besides shout it out.
Yep. I think this is for alignment purposes.
I understand. I just want people to know how I feel about that. And one more thing. At the very, very beginning, and I'm just going backwards because I thought we were waiting to the end, but I don't. We initially had just residents, right? That it covered residents.
Mhm.
And could we also include temporary resident? It was just another thing I'd like to just bring up.
So we had, I think months ago, we went through the process of considering this, and there was concern about essentially businesses then needing to check as people the compliance piece of it seemed unclear, how people would be aware when someone's going in and out and the regular kind of check-ins that would be required. And additionally, some concern about, well, I don't really think you have extraterritorial application there, which could raise constitutional concerns because they're in the state. We're talking about conduct that affects them here. I think that the committee had reasonably decided to back away from that out of fears about practical implementation and those kind of, well, if you started accidentally having extraterritorial application, raising those constitutional implications. So I think it was a nice decision on the committee, like a conservative decision on the committee's part not to embark on that. And no other state is doing it, but it is definitely a cool idea.
Yeah, just flagging it. Okay, thank you.
We can jump. So we were talking about publicly available information. I think that we got through this piece about excluding biometric data. Again, that's making sure that biometric data that's collected without a consumer's consent, without their knowledge, sorry, not without consent, without their knowledge, is picked up by the protections of the Act. That's the idea behind this. The change that you see here to sale of personal data is one concession to what Senate Economic Development proposed. You guys previously had language here that's much more extensive as to what exchange is, and it specifically called out oral communication as one of the means by which personal data could be transferred. So this is a concession to Senate Economic Development. I will say, I think that substantively this is the same thing, but I know that this has been a back and forth between, I know that when Senate Economic Development looked at this piece, they were concerned about it and they did not like that oral communication was called out. And I said, exchange encompasses oral communication. So you may think that you are not getting that picked up, but you should be. At least I think it is a reasonable read to say that that would be picked up under exchange. So if this is a concession, and I guess what you could say you're losing in doing this is that you don't definitively state that that is the case. But it is conceptually possible under this. It will be up to courts as to how they read this. So maybe I overstated that it definitively should be. I think it is a defensible reading of what exchange is. But this is a concession to Senate Economic Development's approach to this. But we otherwise do maintain a piece that Senate Economic Development cut, which is this commercial purposes piece, which I think we've talked about this before. This was related to approaches taken in California about concerns that folks were exchanging consumers' personal data to third parties for non-monetary consideration. Things like what you see here, such as inducing another person to subscribe to certain things, exchange products, or enabling certain commercial transactions. I still take the position that I took last time I talked about this, which is I think that these pieces should be picked up under other valuable consideration. But given that other states felt necessary to call this out, I take it that there is a real problem with this piece, and that's why we included that here. That is not disrupted. This was dropped in Senate Economic Development, but it is maintained here in you guys' draft. So I would say the definition that you now have for sale of personal data reflects one concession to Senate Economic Development, but not a full concession on this piece.
It's very anthropological reading exchange. It's
Gurmeet would be proud.
I don't see why it would, but and I, as I've said many times, I just live in a world of words and not out there in reality, I guess.
Words define reality. That's
Very much how I feel, particularly when this is how I'm spending my time. My reality. Yes, sensitive data. One tweak here. This is the approach. So we're talking about opt-in consent for processing of sensitive data. This is the deemed list of categories, financial information, and we've added here, this is what Senate Economic Development did, including a consumer's tax return. So this would be deemed financial information. So you can say concession, but I'm assuming this is consistent with what you guys would want to do here as well. Another change here, and this is pretty substantive. This previously was personal data collected from a known child, so under 13. Sensitive data, this is now personal data collected from a known minor. This is the approach that Maryland just took in their most recently passed bill to protect all data of minors, so requiring opt-in consent for processing of these pieces. I should say that of all the states that we've seen pass, Maryland is the one I think has kind of generated the most controversy. So there are many things we did not pick up from Maryland's approaches, and I can talk about those when we get here, but those that we thought were nice additions from a consumer protective angle, we've tried to add here. And I think that this is a nice one. The piece that we needed to ensure we did not disrupt in doing this is one of the big constitutional concerns is ensuring that you don't require parental consent for teenagers to do particular pieces. And so what you had was a mechanism that requires consent for minors by parents. That would be problematic. But what we have is parental consent required for children, but not for minors who are not children. So that's kids 13 to 17 through 17. So in this case, they can provide their own consent. They don't have to have parental consent. If they did require parental consent, that would really complicate doing this piece. But I think that we're in a safe place to do this.
John,
Yes.
we dropped J from sensitive.
Yes, sorry, thank you. We previously had a call out here for sensitive data that essentially photographs depictions of people naked or undergarment clad is I think the language that we had, which was based on federal language. Because we've added some new data minimization language, which will, I guess it's beyond data minimization language, because we've added new principles that control our obligations related to the sale of sensitive data, we have dropped this piece. Otherwise, you would be prohibiting all kinds of potential, you might raise free speech concerns in including this particular piece. So we've dropped that, and I think this is a more defensible place to be. And it's tied to the changes that you're going to see at the controller obligations.
Before you go on, can I go back to that minor thing? I couldn't find my mute button fast enough before you jumped to J, sorry. In kids code, I know this is what you were just talking about, I think, but I just want to confirm who consents or to what in the data collection piece? Is that what we were talking about, aligning with the two bills?
So I don't honestly know the latest on kids code, but what's required under this is that opt-in consent is required for known minors. So anyone under 18, but it is important, the known qualifier. This is not saying that people need to start taking affirmative steps to determine whether or not someone is a minor. That would be impermissible. What's happening is if the business already knows that the person is a minor, they will need to have consent for that collection or any kind of processing of the sensitive data, which includes collection.
Yeah, and I guess I took away, you were saying like 13, 14, 15-year-olds can opt in on their own. That's
Yes.
a parent is not required to
That's
do that.
correct.
16, 17, 18, like that makes perfect sense to me. It's that 13, 14, 15 that okay. Just wanted to be fully understanding this one. Thank you.
Yep. It's from 13 through, 13 and older is someone who will provide their own consent under the act. I think we did make changes to targeted advertising. We previously had a more restrictive piece related to a concept of targeted advertising to minors that basically prohibited or required consent for even first party targeted advertising. We have dropped that. This is a concession. We still do have a more fulsome, more robust concept of what targeted advertising is here than what's in, say, Connecticut. So what we have here is, and I can talk about this again, targeting of an advertisement to a consumer based on consumer's activity with one or more businesses, distinctly branded websites, et cetera, other than that controller distinctly branded website with which the consumer is intentionally interacting. So what this permits is essentially first party advertising. But it does not, it also I say prohibits, it requires opt-in. This is a kind of advertising that requires, opt-out for any consumer under the act, opt-in for minors. So there's a difference between the two sets of categories. For this kind of advertising, what is stronger here than in, say, Connecticut is we have this reference to distinctly branded websites. And what this means is a company theoretically under Connecticut's could own a host of different websites, right? But they're branded differently. I think that theoretically under Connecticut's advertising based on any of the activity across their different affiliated websites, regardless of the branding, would not constitute targeted advertising because we have this specific language about distinctly branded website. If a group owned a bunch of websites, but they were distinctly branded, if you started using the activity of the consumer across those different branded websites, they're still owned by the same group, but they're differently branded. That could not be used to generate targeted advertising. So basically, this is meant to get at businesses. You can target advertising based on what a consumer would readily understand to be a first-party interaction. They go to a website, they see that your name is on it. They go to another website, maybe it's slightly different, but they still see that, your logo's there. So they know who they're dealing with. That's the idea behind this concept, is it preserves businesses' ability to target advertising on the basis of the consumer visiting them, but otherwise is not meant to facilitate just broad reach targeted advertising. And this is, I should say, so this is just to reorient, this is a concession in part, but maintaining some of the stronger provisions that you guys had when you passed this out relative to other states. And when we get to the data minimization principle, I will make clear how the changes there mean that there is no disruption to targeted advertising writ large. Okay, we are on the applicability section, page 15. What you guys had when you passed out this bill, you had controlled or processed the personal data of not fewer than 6,500? Yeah, 6,000. And half of that for your second piece related to gross revenue. What we've done is, to start with, expanded or raised the numerical threshold so fewer businesses are subject to the act. It's going to be a step down over a number of years, and we'll come to those at the very end. But the idea is that when this first goes into effect, higher thresholds, a year out, lower thresholds, and then a year out from that, the lowest thresholds, kind of getting closer to where you guys first had passed the bill, and a change from 20% to 25% of gross revenue. And I should call out, when Senate Economic Development made these changes, they did land on this 25,000 figure. So this is, again, a concession to them, but they had a different structure here to just say any business, regardless of, numerical threshold, that derives more than 50% of gross revenue, which may be a small bucket of businesses that actually meet that.
Does this impact data brokers at all?
So, yes, I mean, it affects them in the same way that it affects anyone. If you had I think the key piece will be the gross revenue threshold, but it just depends on how many consumers data brokers are processing the data of those consumers without an empirical picture of how big those are. It's the same question that would apply to anyone else, right? It's, do they meet these thresholds? And so the easiest answer is just to say, in year one, fewer folks are going to be subject to this. Whether that means fewer data brokers are subject to this, I'm not sure. It could.
Yeah, that was my question. I should have asked it differently. Does it ease restrictions on data brokers easier than what we have right now on them? That's my question, but we probably don't have that information.
Yeah, so it doesn't ease the restrictions. It's just whether or not they're subject, and without knowing the picture of how many they process. Now, I'm guessing someone who's a data broker probably processes a lot of consumers. So they may, in every instance, be subject to this. But it is theoretically the case that fewer data brokers will be subject to this in year one. And I think that is the compromise that you guys are striking, is a phase-in approach in recognition of the claims folks have raised and the approach that the Senate has taken to how are we rolling this out. I think this is a concession in part.
Thank you.
Exemptions, I think that we only have one addition here. And this is essentially a slight modification to an exemption that was accepted in Senate Economic Development. In the Senate, there had been a entity level exemption for what is the equivalent of this new exemption. This is an exemption for information, so it's data level, that is processed for purposes of compliance, enrollment or degree verification, or research services by, and this is important, it's a nonprofit organization that is established to provide enrollment data reporting services on behalf of post-secondary schools. So there are two pieces that make this exemption restrictive. One is the kind of nonprofit to which this is available. It's only for those that are established for this particular purpose. So I don't imagine this is picking up a lot of nonprofits. These are folks who are established to provide enrollment data reporting to post-secondary schools. They may do other things as well, but among their purposes, they're established to provide that enrollment data reporting services. And then it's only data level. It's for information that is processed for specific purposes as well. So those are the two restrictions, kind of nonprofit and what the information is processed for. Admittedly, research services is a broad category, so I will flag that. But I think given that you have the two pieces together for particular purposes and only a narrow set of nonprofits, the hope is that this is restrictive enough to permit those folks who are providing degree verification to jobs and schools to continue to operate without needing to worry about this piece. And this was a concession. We jump down to consumer personal data rights. This is really cleanup changes that you see here in 2. This is the same content as what was here before, but I think it's worded a bit more clearly. I'm happy to talk about this if you want to, but it's the same as what's before, so I don't know that we need to go into this. It's just easier to read now. There is a substantive change to this subdivision 4 on line 6, but I think this is consistent with everyone's expectation. This is making clear, and this should be comforting to industry, that if they have a requirement under law to retain personal data, they are not required to delete the personal data at consumer request. But I think that was probably already in the act elsewhere. This just makes it clear in the consumer data rights that that's the case. Subdivision 5, again, this is just reordering. This is not a substantive change. This is just making it a bit easier to read this particular section. The real biggest substantive changes come in the next section. So this is the heart of the updates that have been made here. This is not a substantive change. This is just making it easier to read the section. Duties of controllers. This is where the real meat of the changes are. The first piece, when you guys sent out the section 2419, you had data minimization principles here that said something like, shall process only as reasonably necessary and proportionate to provide products or services, or for another disclosed purpose that is compatible with those disclosed purposes, or if they obtain consent, they could do it for another purpose. The point that folks raised fairly when this reached the Senate was that because the processing is tied to that restriction on what is reasonably necessary and proportionate is tied to the product or service offered, because someone's going to a website not to receive targeted advertising, that technically businesses could require opt-in to engage in targeted advertising. I don't think that that was you guys' intention. So this was something that was resolved on the Senate side in a different manner than you see here. I don't necessarily have to go into it, but they changed away from products or services to go toward what is reasonably necessary and proportionate to disclosed purposes. Now, what I would say about that is they did solve the concern about requiring opt-in for targeted advertising, but what that regime produces is basically as long as a business discloses their set of purposes to you, they can do what they want for those purposes. Now, it's meant to be what's reasonably necessary and proportionate to those purposes, but I don't know how strong of a restriction that is. To me, that language about what is reasonably necessary and proportionate, and I can talk about this language now, what is reasonably necessary and proportionate makes more sense when we talk about limiting collection. it's easier to say what is reasonably necessary to collect the data to provide a particular service than to say what is reasonably necessary to process for a particular purpose. So what we have here is a slightly different data minimization principle, but I think this is the most intuitive one that I have seen yet. And this is in part pulled from Maryland, but we do not accept all of their changes because they do have some stronger prohibitions that we did not want to adopt here. So what does this say? This says a controller shall limit the collection of personal data to what is reasonably necessary and proportionate to provide or maintain a specific product or service requested by the consumer to whom the data pertains. So this is saying a consumer goes to a business, they go to their website, they purchase something, they offer up their data to that business. Now, what the business has to do is limit the collection of that data only to what's required, what is reasonably necessary, and it allows them to make that determination. It's not a strictly necessary bar, it's what's reasonably necessary to provide that product or service. So that's the consumer making an exchange with the business saying, I'm handing over information and I receive what I want in return. And now the restriction on the business is not what was in the previous draft, that the restriction is on the processing what's reasonably necessary and proportionate to those purposes. Now that they have that limited data, they can do not as they please, but they can process that data for the purposes that they disclose, and we'll come to the restriction on that piece. But I think that this is a more intuitive concept of data minimization. Consumer engages in consensual exchange of information for a particular product or service, and the business, now that they've received that data, can use the data for the purposes that they have disclosed. I can pause.
So that's like, I'm gonna use this example in the past, like the Walgreens, you agree to give them, you shop there, they have your information, they know what you like, so you get coupons. An online coupon, that's might be.
Yep. Yeah, and I will talk more about this when we get to the shall nots, which we'll get to shortly, because there's an interaction with that piece, but I think that this is fairly clear language as to what businesses are restricted in doing here, and avoids the targeted advertising problem. This does not produce, they can collect data and then they can engage in targeted advertising on that basis. They may collect less data than they were going to collect before because now they have to limit that to what is necessary to provide the product or service, but they can continue to engage in targeted advertising. And given that they're going to engage in targeted advertising on the basis of what you went there to purchase or receive, the information that they receive from that exchange is going to be what they need to engage in targeted advertising. So I think this is a fair compromise from my perspective. The changes you see here at 3 and 4, this is again kind of a tidiness change. This used to be one big subdivision. I've broken it out to make it a little bit clearer how the revocation of consent is a separate piece. So what shall a controller not do? This is the other data minimization principle tied to this. They shall not process personal data for a purpose not disclosed in the privacy notice unless the controller obtains the consumer's consent or the purpose is reasonably necessary to and compatible with the disclosed purpose. So this means the business can engage in the processing of any disclosed purpose that's in that privacy notice. If they want to go beyond that, they need to obtain consent unless essentially the purpose they want to go to that's not disclosed is sort of already implied. It's reasonably necessary to and compatible with a disclosed purpose. So what businesses will do, they're going to provide the privacy notice. They can process with the limited data that they collect for the purposes that are set out in that privacy notice. And then if they want to go beyond that, they'll obtain consent for another piece. And that is just a way of maintaining the notice provisions of the act. A consumer just needs to be on notice what their data is being processed for, but otherwise it's sort of business as usual, and the constraints are on collection and then specific restraints on what can be done with sensitive data. So I would say the broad effect of this is that for personal data writ large, what the act does is create a notice regime for consumers, and then for sensitive data, special kinds of restrictions apply. That's kind of the idea here, is that businesses can operate with a set of personal data without needing to make large modifications to what they do, but they do have to take different steps for sensitive data. Okay, so maintain from the previous draft, controllers shall not process sensitive data without first obtaining consent, or if the consumer is a child, processing in accordance with COPPA. Here is this is probably the biggest update of this change. And this is, beyond just cleanup changes for compromise struck with the Senate. This is a real step out. This is something that Maryland does. This is a prohibition on selling sensitive data, full stop. This is for processing sensitive data. So all kinds of processing of sensitive data require consent. But for sensitive data, we're saying if you sell it, that's just prohibited under this act. So that's part of why we dropped one of the categories that we had under sensitive data and tightened up the other pieces. But this is a big step. So I just want to pause here and say that this is the biggest change, I think, in this draft. And if you guys want to talk about it, go for it. But just wanted to recognize that and not speed through this.
Stephanie, is it okay? I keep jumping in. Sorry, go ahead.
Go ahead, Edie.
I was just going to say I like this a lot, and I appreciate the understanding of what we were asking for and figuring out how to get it onto language.
Yep, and there's a way of seeing this as, selling is a kind of processing. So basically what you're saying is 2 tells you that consent is required, but for this one category, for this one kind of processing, we go a step further and just say, even in this case, consent is insufficient. And I think it makes sense intuitively, if we think about it, that we don't want our biometric data, our tax returns, or our account numbers with their passwords sold to people. It's an intuitive concept that I think is not hard to understand. But I do just want to flag that this is a new kind of prohibition that, again, Maryland is doing this, but it is to be seen how this will, I don't think it's confusing how it works, but it will be seen how folks react to this. The piece that you see here in 4 is substantively the same as what's in the draft that you guys passed out. Maryland goes further than this and had a full prohibition on processing minors' data for these purposes. I think you could have real First Amendment concerns for the targeted advertising piece. And the point about selling the consumer's personal data, this is in a way already. Actually, this is a good point. We could conceivably drop C here because it should already be picked up by 3. What 4 is saying is you have to get consent to process the personal data of a known minor for the purposes of targeted advertising, profiling, or selling that consumer's personal data. But we already have a prohibition on selling sensitive data, which includes the data of minors. So I think we actually should do that, drop 4C. Does that make sense to you guys? Just to,
Yeah.
We aren't trying to permit selling of minors' data with consent, and I think that you could read this to say that. The one difference I would say here is there is a slight difference. In sensitive data, we say selling we say data of a known minor. And in this case, we say the controller knows or consciously avoids knowing is a minor. So there could technically be a broader category captured here, right? So we could say in this is interesting. Maybe that's a fair compromise to take, but does that difference make sense, that if we drop C, it would mean that folks could sell the data of minors if they did not definitively know that that consumer was a minor. Under what we have here in 4, we're saying they have to obtain consent to sell minor if they consciously avoid knowing, which is slightly different than if they do definitively know. But that, given that you're outright prohibiting the selling of known minors, maybe that's a fair compromise to strike, but I will let you guys figure that out. Does that concern make sense? The categories aren't exactly the same. Technically, you have a smaller category of consumers who are going to fit into that known minor prohibition on selling their data.
So is it okay, Stephanie?
Go ahead, yeah.
So we've been talking about a full prohibition on selling data of a minor, right? Throughout two different bills, I guess we've been talking about that. And I know you're not an expert on both of them. But just for the committee, and what you're saying is if we drop C, a minor's data could be sold if the minor agreed to it?
No, so if we drop C, what it means is a business could sell the data of a minor that they did not definitively know was a minor. That's what it means. But they are prohibited from selling the data of a minor that they know to be a minor, a consumer that they know to be a minor.
Okay, and then,
Sorry, go ahead.
yeah, the ostrich defense that we've been talking about, right, should have known, is that anywhere else? I know that it's here, consciously avoids knowing, but because I think that's important. I think that's an important piece of this that we use a lot in Vermont, and that because we don't want to require data collection to figure out if somebody for sure is a minor. We know that they collect the data enough to know who they're targeting and roughly what age they are, if not exactly what age they are by their birthday and all of that. We know that that's already happening in a lot of instances. So I want to make sure that that consciously avoids knowing stays in there.
So that piece is staying. The question is whether or not to drop C. And I would say if you just include C as is right now, I think it would be a defensible position for a business to say, I mean, they might lose this, but I could see the argument that they say, look, you prohibit selling sensitive data in 3, but then in 4, you say that we can obtain consent essentially to sell a minor.
Yeah.
Yeah. So they're, at the very least, their intention, I mean, you could, so I think it's easier to drop C, and maybe that will be a happier place for businesses to be given the other pieces here, because then they know that they aren't going to be on a violation for selling the data of a minor that they don't know to be a minor. It's only in cases where they definitively do know them to be. The other, I'm trying to think of a way, if you wanted to preserve exactly this, you could say something like selling the consumer's personal data of a minor that is not definitively known to be a minor, but it just starts to read very oddly and produce like strange. It's almost like you're incentivizing them to take steps not to know if someone is a minor, so that they can then continue to sell the data. So I don't think we want to have that intent.
Everyone agree to take?
Yeah,
That's-
I think it's gonna
Oh.
conflict with 289 too, John, so.
Okay, so let's just,
cleaner to pull it.
Yeah.
it's definitely easier to drop it.
We don't want to conflict with 289. Did you have a comment?
What?
Did you have a comment?
Kind of, but not yet. I'm thinking.
Okay.
What you see here in 6, we had this in an earlier draft and then deleted this on the basis that what we currently have is 7 probably captures a lot of this. But this is an easy piece to include. I don't think it makes a huge substantive addition. The difference that it does make is it's saying if someone violates state or federal laws that prohibit unlawful discrimination, that would be picked up as a violation of this act if they're processing personal data in violation of those pieces. I don't really see this as a huge substantive addition. This is largely captured by what's in 7, but for consistency with other states, maybe it's worth maintaining this call out. Clean up flow through changes in 7. That's really your biggest changes here. We will get down to other pieces. We're talking here on page 33 about what a controller needs to do to provide mechanisms for consumers to exercise their rights. This is authentication of a consumer's request. And what the new language that you see here is clarifying is that use of an IP address to estimate the consumer's location is sufficient to determine their residency. And that's a piece that you would want for those authentication requests if they're in fact a Vermont resident and can exercise this act. So this is just to make clear what businesses can do to authenticate. On 34, we've updated language throughout the draft that used to say actually knows or willfully disregards to instead say knows or consciously avoids knowing. That's meant to be conceptually the equivalent of that language. This is language you see here that's already in Title IX, so that's one of the reasons for the changes. And also the willfully disregards, just a plain English reading of it, not a legal reading, to me would seem to imply potentially a knowledge standard and therefore not be adding anything beyond actually knows. So I think this is also a bit clearer than what actually knows or willfully disregards means. But at the very least, it's conceptually the same as what other states are doing. It's just using Vermont language to describe the same piece. So this is your duties of controllers to minors. The changes that you see here, or that you won't see here because they're deletion, relate to alignment with kids code. So the first piece is here. This used to say, shall not process a minor's personal data for any purpose other than a processing purpose that is reasonably necessary for. This has been upgraded to strictly necessary. And the same piece you see in 3, processing a minor's personal data for longer than is strictly necessary to provide the online service product or feature. So in both cases, making it more restrictive as to what is required in dealing with minors' personal data for these online platforms. What is not visible here is previous subdivisions 4 and 5. This is for alignment with kids code. I think that you guys are dealing with this there, so they've been dropped here. But previously 4 said it was either geolocation or processing. Gosh, I can find it. Yes, the previous rep, yes, using system design features to extend use and collecting a minor's precise geolocation data. I understand that those are being taken up in 289, so they don't need to be dealt with here. So they've been dropped here, not to duplicate. Otherwise, this section is largely the same as before. Duties of processors, this remains the same. You're almost there. Same updates for actually knows or willfully disregards to knows or consciously avoids knowing throughout the draft. This is a cleanup change you're seeing on section 2425 de-identified data. The intent was to have this take reasonable measures language in the draft as passed out. We've made this update to the definition of de-identified data, and then I forgot to add this here. So this is just cleaning up to make clear that there's no difference between the definition of de-identified data and what's required under this particular section. This is consistent with the intent that you guys had as passed out. Okay, construction of duties of controllers and processors. There is a couple changes here. We used to have a subdivision 4. This is what we're saying. This chapter shall not be construed to restrict entities' abilities to engage in particular ordinary course or internal purposes. We previously had a subdivision 4 that said shall not be construed to restrict the ability to essentially act in accordance with a contract under 2421B with a state or local government entity. The reason that this has been deleted, and I think this is included at lobbyist request, is that language technically doesn't accomplish anything for them even. So it's superfluous. Technically, just to explain why it is superfluous, those local government entities would be exempt from the act under our exemptions, and therefore there would be no contract under 2421B by which a entity would need to comply. In addition, because anyone acting under a contract with a local government or government entity would not be acting as a controller, even if you think of that government entity as being exempt and they're asking themselves, well, the person I'm working with is exempt, but I may not be. Because they're under a contract working with that person, they're not determining the purposes of processing. They're therefore not a controller. And if they're not a controller, then they aren't going to be subject to the obligations of this act. So think that language is just superfluous. It's not needed here. The change you see at 5 is in relation to the changes we just talked about with data minimization. So this says, shall not be construed to restrict ability to provide a product or service specifically requested by the consumer. That's fine, but we want to make clear that the data minimization principle that limits collection of data to what is reasonably necessary and proportionate to providing that product or service is maintained. So this call out to consistent with subdivision 2419A1 is meant to do that. It clarifies, yes, of course, you can provide the product or service, but that doesn't mean you can just do whatever you want in terms of data collection. You've got to comply with 2419A. I think even if you didn't include that, that should be clear intent, but this makes it even clearer that that is the case. I guess I'm running out of time, but we are almost there.
We have you until
9:45.
9:45.
Okay, great. That's great. So we have language here. This is drawn from Colorado. I don't think you have to have this, but this is nice to have this. So chapter shall not be construed to require controller, processor, or consumer health data controller to implement an age verification or age gating system, or otherwise affirmatively collect the age of consumers. That first sentence, this is tied to that knows or consciously avoids knowing. We are not imposing a requirement that businesses investigate and determine folks' age. It's meant to preserve basically, do they already have knowledge, or do they have a reasonable basis already on which they should know that someone's a minor? We're not asking them to take additional steps. For instance, Maryland is doing knows or should know is a minor, and that is potentially more dangerous because that could be taken to mean that businesses should engage in discovering whether or not someone is a minor. And so you may have constitutional concerns here. This language is nice. You are limiting, you are protecting yourself from liability, including language like this. And then the second sentence goes even further. A controller, processor, or consumer health data controller that chooses to conduct commercially reasonable age estimation to determine which consumers are minors is not liable for an erroneous age estimation. So if they're doing commercially reasonable efforts to determine age, they're not going to be liable on that basis. So this is, again, trying to protect businesses' ability to continue to operate as they are, and then just calling out that if you do know, or you have a strong basis for knowing, in those cases, apply the extra protections. And again, we wouldn't be the first to do this. This is what Colorado is doing as well. Although I should say, I'm not sure that the Colorado language is new. I'm not sure that it's actually passed or been signed yet, but this is consistent with the approach that I think that they are taking there. So changes to the enforcement section. What we have here is an enforcement section that relies on, in subsection A, the underlying consumer fraud protection statute. So this provides for both AG enforcement and the underlying private right of action already existing in Title IX, which is under 2461 subsection B. And this language that you'll see is consistent with what the Kids Code language does. So you have that piece. AG has the same authority to adopt rules to implement this section as under Chapter 63, which is your consumer protection chapter. We maintain the cure period, 60-day cure period. You guys have seen this language before. Same pieces for consideration and a requirement of reporting on notices. I'll take a look at your email and.
Oh, no,
Okay.
yeah, you don't have to, it's for later.
So this should be pretty familiar to you guys, but just to call out, you had an in-section PRA built out. This, you're going to see multiple enforcement sections in the bill, and we'll come to those. But this first one, which is what's going to be immediately in effect, is just relying on the underlying existing private right of action in Title IX. Last piece of the act, confidentiality of consumer health data. This is just a cleanup change to subdivision 3. This previously said any healthcare facility, mental health facility, or reproductive or sexual health facility, because those facilities are kinds of healthcare facility. This is just adding them as including any mental health facility. So it's a way of preserving the call out to those particular pieces to say we are definitively saying establishing a virtual boundary around mental health facilities or reproductive or sexual health facilities is prohibited under this section. But just cleaning up to say that is a kind of healthcare facility. That's what the including any language is for. For publication and public education and outreach, just one tweak to what you guys passed out, which is to say on page 58 that the Attorney General may have the assistance. Sorry, there's two changes. When you guys passed this out, you tasked the Attorney General and ACCD with engaging in this effort. The understanding was that ACCD doesn't really want to be doing this. The references to ACCD have been pulled out, and instead it's tasking the AG with that education and outreach. However, under the subsection E that you see here, the AG may have the assistance of the Vermont Law and Graduate School in developing that education outreach and assistance programs. This was on the basis that they, I think, want to do this, but I can't so much speak to that piece. And again, I think the testimony throughout has been that the AG has the capacity to engage in this effort. So I don't think that the removal of ACCD is a dramatic impact on whether or not this is achievable. I think it's actually just aligning with folks' actual intent, like what they want to do. No, you're good. Okay, big changes in section 3 to the data broker section. This is basically to accept essentially all of the changes that Senate Economic Development made here. This is rolling back. I'll go through this to show what happened. But the ultimate effect of the language that you have here is just to require additional civil penalties and fees related to registration, and then to require one new burden on data brokers, which is data credentialing, but does not include the opt-out language that had been passed out of here. So, and requires, sorry, also notice of data broker security breach, which I think has been the kind of big request all along from the AG's offices to ensure that we capture notice of these particular kinds of security breaches. So there are new substantive provisions if this bill passes. There are new obligations imposed on data brokers by this section, but we are not rolling out the individual and general opt-out pieces. And the reason for that is, one, concession to Senate Economic Development, two, folks' complaint that there's some tension between the opt-out in the data broker section and the language that's in the Vermont Data Privacy Act. The ultimate place that landed was making the data broker section look an awful lot like the Vermont Data Privacy Act, at which point they sort of become superfluous, because if they're subject to the Vermont Data Privacy Act, they're already going to have to comply with that. So why have another provision that does it? And additionally, from my perspective, the negotiation that was happening on the opt-out piece was having substantive effects on what was happening in the Vermont Data Privacy Act. And I am guessing that that was not the intent, was to allow the data broker negotiation to drag down the Data Privacy Act. So this is a weighing of priorities as well. Additionally, given that you prohibit the selling of sensitive data, that's a dramatic impact on data brokers. And so I think the changes that you made to the controller obligations already has a pretty dramatic impact. For data brokers, you can see beyond that data broker security breach, notice what's required is these additional penalties for failure to file information or omitting required information or filing materially false information. This is what you guys had, except one more concession to Senate Economic Development. You guys had the penalties kick in after 5 business days. And what Senate Economic Development proposed was after 30 business days, so significantly longer period. Given that you are including the substantive modifications, the prohibition on prohibiting selling sensitive data in the Data Privacy Act, and given that you have rolled back this is a choice for you guys, but I think if you're trying to make concessions to Senate Economic Development to reflect a real compromise here while you're still getting things that you want, I think that this is maybe an easy one to do, but it is worth saying that those penalties wouldn't kick in for failure, for omission of required information, or for filing material incorrect information until a whole month after that failure. But I think that I didn't understand anyone to be taking objection to this particular piece.
Okay, that.
I'll say I don't love it, but I can be okay with it. Is that fair? I mean, the reality is once the information is out there, it's out there, and it's really hard to pull it back, and more damage can happen the longer it's out there. But
So to respond to that, this is just about registration pieces. This is not about what data brokers are actually doing with your information. This is if a data broker omits required information from their registration form, or if they file misleading information in the registration form. When do penalties for those kinds of registration failures kick in? It's not related to consumers, except to the extent that the consumer is denied the information they need by the registry, essentially. So this I don't think implicates those concerns.
Great, thank you. I appreciate that clarification.
So what remains of the previous opt-out section? We still have this credentialing piece, and what this is, and I don't think we ever really talked in substance about this. So it was only recently that I kind of realized the value add of this, but maybe it's been apparent to you guys all along. We focused so much on the opt-out, we didn't talk much about this particular subsection. This imposes on data brokers a requirement that they maintain reasonable procedures to ensure that BPI is used for legitimate purposes, including requiring prospective users to identify themselves, certify the purposes for which that information is sought, and certify that it won't be used for other purposes. That the data broker make reasonable efforts to verify the identity of new users and the uses certified by those users prior to furnishing the information. So this is imposing obligations in advance of turning over that information, and requiring that data brokers not furnish the BPI if they have reasonable grounds for believing that it will be not used for a legitimate and legal purpose. So you can imagine if they have all kinds of indications that, it's like through the, I don't know exactly what the mechanism would be, but if they have strong indications that someone is engaging in criminal behavior or the like, this would say you're prohibited from turning over that information. So these are substantive additions, but we don't have the opt-out pieces. And previously there was an exemption section in this section 2448. Given that you have pulled back the opt-out, we have eliminated the exemptions. I understood the exemptions to be a request for exemption from the opt-out provisions. And so in the absence of those opt-out provisions, I don't think you need them anymore. Section 4, this is a data broker study, and this is tied to the removal of those opt-out pieces. What this says is that the Secretary of State, on or before January 1st of next year, shall, in collaboration with ADS and the AG, review and report findings and recommendations to committees of jurisdiction concerning mechanisms for Vermont consumers to opt out of the collection, retention, and sale of brokered personal information. Basically, this is a study to look at the previous language that was in this section that has now been pulled out, because some of the testimony that's been heard is that the Secretary of State would not have capacity to implement the general opt-out. And if that's the case, the opt-out section doesn't get you very far. An individual opt-out is unlikely to be particularly effective with data brokers because there is no direct relationship between the consumer and the data broker. You really need the general opt-out, is my understanding, to achieve anything with data brokers. And so this is a way of gathering data and coming back with a plan with the Secretary of State, who will be the one in position to say whether or not essentially this is achievable and what it would take to do that. So that's what this study is meant to do. They'll have to include they'll have to look to that individual opt-out. They have to consider rules, procedures, and framework for implementing this is essentially the general opt-out, the accessible deletion mechanism that California is offering, how to design and implement that state-facilitated general opt-out, operational costs, mitigation of security risks, which we understand is a large portion of the cost that would be incurred, and other relevant considerations. Section 5. So now we're jumping into what you're going to see as duplicative sections of pieces before, and these are sunsets of previous provisions, so I'll walk through those. Section 5 is a part of your tiered rollout of the applicability thresholds. So the first threshold is going to come into effect when the Act comes into effect in 2025, so July 1st, 2025. This Section 5 would not go into effect until a year later in 2026, and this is lowering the thresholds from 25K to 12.5K. And then for the gross revenue piece, if a business has controlled and processed personal data of not fewer than 6,250 consumers, 6,250 consumers, and derive more than 20% of gross revenue. So that's for your 2026, a middle step in your applicability threshold, so a step down.
So, where does the date, where are the dates?
They'll come at the very end.
Okay, thanks.
Yep. The next section you see, section 6, this is stepping down again, and this is for 2027. So you're going from those new thresholds that we just walked through to half of those. 6,250 consumers, and for your gross revenue piece, 3,125. This is basically ending up in 2027 with the thresholds that you guys had proposed starting with. And just to call out again, the thresholds that you proposed starting with in July 1, 2025, that 25K threshold is what Senate Economic Development has. So you can see this as, in a way, starting with what Senate Economic Development has proposed for thresholds with some modifications, and then stepping down over the course of 2 years to the thresholds that you guys had proposed on this side. Section 7, this is another sunsetting provision for the enforcement pieces. So the rollout first in July 1, 2025 is for reliance on the consumer fraud statutes, meaning both AG enforcement and the underlying private right of action. And then what this does is it removes the cure period. So when we start, we're going to have a cure period permissible for AG action. That's what you see in subsection C, and we're going to have reporting from the AG on that curing. After 18 months, so this would come into effect January 1 of 2027. Yes, I need to check that. I think I've done this. Yep, I'll need to check this piece. This will be, after 18 months, this will be removed. And then in 2020, let's see, on July 1, 2026, the private right of action in statute, so not reliance on the underlying statute, but a specific developed private right of action would be made available in July 1, 2026. So let me walk through what this does. This is, you already have the underlying private right of action in the consumer fraud statutes. This is, and what's important to call out about that is the underlying right doesn't contemplate statutory damages. It contemplates actual damages, meaning that folks need to prove their damages under the underlying right. If you have statutory damages, meaning that someone can seek something like the greater of 1,000 or actual damages, it means that a consumer has more incentive to go to court to enforce their rights. So what this private right of action coming into effect in July 1, 2026 would do is to make statutory damages available. So folks could know that they're going to get the 1,000 if they win their case, that or the actual damages. But to call out what you see here in C, the PRA would only be available for specific kinds of violations. And this is reflecting the approach that Senate Health and Welfare is taking, which is a consumer who is harmed by violations of subdivisions 2419B2, 2419B3, or section 2428 may bring an action for that alleged violation. So 2419B2 is processing sensitive data without consent. So if there's a violation of that, which is a big bucket that includes things like health data, biometric data, and the like, or if there's a violation of 2419B3, which is selling sensitive data, or section 2428, which is your consumer health data specific section, which is things like the prohibition on geofencing. Violations for any of those sections would trigger this private right of action, would make this private right of action available with statutory damages. And that would be available if the consumer notifies the consumer, the business, of that violation, and then within 60 days following receipt of the notice, the business fails to cure the violation, or we're talking about a situation where no cure is possible, like prohibitions on geofencing, you may not be able to cure that. And this is the same language that you guys had in the language that you passed out. So this is the statutory damages that I was talking about, the greater of 1,000 or actual damages, and then a requirement for a report on disclosure of those pieces. Finally, section 9 is rolling back this private right of action after 3 years. So this would eliminate it after data collection could happen, and we could see what the effects of it are. So in 2029, that statutory damages private right of action would go away. I'm going to try to just wrap up because I know Rick needs to hop in the seat. This is your effective date section. I will go through this again when I go back to my office because I think the cure period phase out may need 1 more year, but I will check that. And if you have anything, please email me, or I'm happy to answer it now, but do want to let Rick hop in the chair if I can.
Okay. Thanks so much. Yep.
Just wondering, sometimes when we do these kind of, like we're establishing a private right of action and then we're getting rid of it, with different effective dates, we have like a report back.
Yes.
Are we, did I miss that?
We're doing a report for the PRA here. We're doing annually on a report February 1st to submit a report disclosing number of actions, number of violations broken down by statutory basis, proportion proceeding to trial, most frequent violators, any other matters deemed relevant. Yep.
I'm sorry, what's the date on the report, July?
That would be, so once that comes into effect, which it comes into effect July 1, 2026, it's annually on or before February 1st. So the first report you would get is February 1st, 2027, and you would receive that until this is phased out in 2029.
Perfect. Thank you so much, John. Really appreciate all your work on this. Terrific.
Yeah.
I will drop the 4C piece that was in tension, and I will confirm the cure period phase out.
Okay,
I can be back with that later today. Yep. All right.
thank you.
See you guys.
Appreciate it. Okay, so, I kind of feel like we should keep plodding along. If anyone needs to take a break, go ahead and, or would you like to take a 5-minute break?
Yeah, maybe we.
All right, let's take a 5-minute break then.
Yeah, if we have
We
two
did
people
quorum.
stepping over.
Yeah.